Right now, immense volumes of your personal data, your exact location, financial history, and biometrics are being siphoned into massive, centralized corporate servers. Historically, protecting this information was left to corporate discretion. Security often relied on voluntary internal policies or was buried deep within unreadable terms of service agreements that few users ever actually saw. The Digital Personal Data Protection Act of 2023 replaced these voluntary practices with specific legal requirements for how organizations must handle your information. The central mechanism of the Act relies on a specific legal title. When an organization collects your data and determines how to process it, they are now legally classified as a data fiduciary. This title carries strict liability. If a fiduciary uses your data to make a decision about you or shares it with another company, they bear the legal burden of ensuring that data is entirely complete, accurate, and consistent. Section 8 of the Act mandates reasonable security safeguards, legally requiring organizations to implement defensive measures to protect personal data against breaches instead of simply storing it. By codifying these mandates into law, the Act attaches specific financial penalties to security failures, placing the legal and financial burden of protection on the organization rather than the individual user. While the law sets the requirement, the 2025 draft rules provide the architectural blueprint for these safeguards, organized into distinct pillars. The first pillar covers technical measures. Fiduciaries are not permitted to leave data sitting in its raw, readable state. They must actively alter it to ensure it is unreadable to anyone without authorization. Rule 6 outlines the specific technical methods required, including encryption, obfuscation, masking, or replacing the personal data entirely with randomized virtual tokens. The second pillar focuses on the digital environment. These operational measures require fiduciaries to implement strict access controls on the computer resources where the data is actually processed. To maintain visibility, the rules mandate the use of appropriate access logs. Systems must be constantly monitored to detect and investigate any unauthorized entry attempts immediately. To ensure these threats can be investigated and remediated, fiduciaries must retain these specific access logs for a period of 1 full year. Technical data alteration combined with constant environmental monitoring forces organizations to treat data security as a continuous, monitored process rather than a one-time setup. The third pillar addresses ecosystem accountability. A data fiduciary's legal liability does not vanish if they outsource their processing to a third-party service provider. If a fiduciary shares information with a data processor, they must execute binding contracts, forcing that processor to implement the exact same technical and operational safeguards. The rules also mandate business resilience. Fiduciaries must maintain robust data backups to ensure continued processing if the integrity or availability of their primary systems is ever compromised. Previously, a server crash or a third-party breach often resulted in the loss of consumer data, with few avenues for accountability or recovery. By legally binding processors to these standards and mandating backups, the law creates a continuous chain of accountability, preventing corporations from deflecting blame. What is the legal procedure when these architectural safeguards are bypassed and a breach actually occurs? Rule 7 requires the data fiduciary to promptly and simultaneously intimate both the Data Protection Board and every affected individual, explaining the nature of the breach and the steps taken to mitigate it. For companies processing massive volumes of data, the law scales with the risk. These significant data fiduciaries must appoint a dedicated data protection officer and conduct periodic audits to verify their security posture. Once the data is no longer needed for its specified purpose, or if a user withdraws their consent, the fiduciary and their processors are legally obligated to erase that personal data completely. These mandates, from encryption to mandatory erasure, form a legal architecture designed to protect the information of over 1 billion individual citizens. The DPDP Act establishes a framework where data protection is no longer an optional business practice. It is a legally binding requirement for architectural defense, returning ultimate control of personal data to the citizen.